first matter and the only matter by video conference that comes before us this morning is State of Ohio versus Bryan Peck. Each side will have 15 minutes to argue. If you are the appellant and wish to reserve 5 or less minutes for rebuttal, please let me know when you get started because I'm keeping the clock this morning. We have read the briefs and we are ready to before I forget, please don't use the names of any victims or minors that may be associated with this case as we are posting this video on YouTube. We've read the briefs. We're ready to proceed when you are.
Well, then, very well. Thank you, Your Honors. Here we are in a very unusual setting, and it's a pleasure to be in front of this court, even though I'm not sitting physically in front of you. May it please the court, I am Richard Kudishi. Your Honors, I am court-appointed counsel for Bryan Peck, and I've come here today, I've asked to have this oral argument because I think it's an important one. I think you have a number of issues that this court can solidify upon and can give instruction and refinement. Just in general, I'm going to talk about 3 different things. We have a trier of fact here that hears it all. Now, that's part of an ineffective claim. I'm not going to really be dwelling on that. Oh, excuse me. But the second thing is that, look, the state's case just doesn't add up. And more importantly, the third thing is the trustworthy nature of the report, the remarks given by WS are just something that allowed the trier of fact to lose sight and to lose its way. Bryan testified that during the month of December of 2017, both of the parties worked full-time. They worked from 6 a.m. to 4 p.m. They had a babysitter. So we do have WS had a babysitter. In this instance, on December 9th, 2017, the claim is my client had sexual contact with WS, and he is convicted of rape, a felony of the first degree, sexual battery, F2, and GSI F3. Those 2 merged with felony 1 and rape. So he was sentenced to 15 to life. So the tactical or whatever reason for having a trial to the court is part of my ineffective claim, but more importantly, the decision-making of the trier of fact was from 2 statements, really. So Gail says something, Bryan says, Bryan talked about working in the morning of December 9th, 2017, talked about going to work, coming back, laying back on a Saturday. He changed his clothes. One of the most significant things in this trial is the layout and nature of this house. And it's very critical the court looks at that. You have a small 1-bedroom apartment where the kids stayed in 1 bedroom. Bryan and Gail stayed in another, which was the living room, dining room, TV room, an open environment where their bedroom was, and there was a kitchen. The kitchen where this event began, where Gail was standing, is just a few steps away from where the claimed criminal act took place, so the bedroom. So Bryan comes home, changed into a knee-length basketball short, and that's also important. Grabbed a beer, had some lunch. So Gail was in the kitchen doing some dishes. Bryan said they had a quote-unquote frictiony relationship, but they were getting along, but not so much frequent intimacy with one another. So he went into the kitchen, he saw Gail was bent over, he got turned on, and he began initiating some sexual romance. And he says that he took his penis out and started rubbing it on his wife, against his wife, and doing this with the basketball shorts on. And that's also significant because if you know basketball shorts, they're knee length. So whatever was going on there, he got an erection, tanning out the shorts, he said. And so they were interrupted when WS came out and said, hey, can you help me with the TV? So he walked the few steps, Bryan walked the few steps into the room, into the small room from where Gail was, and helped WS with the TV. He still said he had an erection that was, tanning out. So when you look at that factual basis there, it's great significance. It's undisputed as to the size and location. So he goes into this small room, just a few feet away, a few steps from where Gail was, in an open door. And I'm going to be graphic a little bit here. He has he's with the 2-year-old child and WS a few steps from Gail, and supposedly he's getting WS to suck him off. Now, I know how that may sound, but it's unreasonable, and that's where the weight and the sufficiency becomes critical. How is some guy going to be around the corner from mom having oral sex with his child? So that goes to our weight and sufficiency claim. I'm not going to delineate the two. You know the standards quite well, and I think we have briefed that well. Now, Gail doesn't agree with this. Gail obviously feels it's a little different. She says there was no intimacy going on, and she disagrees that he became sexually aroused by her. But she surely agrees, it's undisputed, that the size, the location of where WS was, and that the door was open. So the other point of suckers, you hear suckers throughout the allegations here. He would coerce or entice WS to give him oral sex and then give her suckers. Well, in this case, Gail testified that Bryan came out, asked for some candy. He didn't ask for suckers, he asked for some warheads. So it's inconsistent with other alleged claims of sexual activity where he would get oral sex and then give WS a sucker. He came out and asked for warheads, and Gail gave him the sucker. So there's another critical point. The other factual basis is when Gail walked in there, she did not say that she saw any oral sex activity going on. She said she saw WS staring at his erection. That distinction's important as well. So WS was staring at him, and then listen, this is what Gail quotes WS is saying. This is really significant as well. She said, "Dad told me his wiener is a sucker and not to tell anyone ever." So now this spontaneous statement, supposedly she calls his penis a wiener, and then she says, "Hey, he also told me don't tell anybody." What little child with no preschool at 5-year-olds is going to say that spontaneous remark together? Now, we move into the issue of what, and Gail did not tell the police, by the way, that she saw Bryan shoving WS away. But what's significant is about the name. So there's a story behind WS calling her vagina a flower. I mean, their former roommates, girls called it a flower. She was taught to call her vagina a flower, but now all of a sudden she's calling it a pee-pee, or she's calling a penis a wiener, which the conversation was, we told her, call your vagina a flower, and then you're going to call a boy's penis his privates. And that was not what the terminology that was used. I got to move into the competency topics. Critical. So the judge, the trier effect, and in all due respect, he is a great jurist. I know this because I read so many transcripts with the judge. But he's hearing everything. So he hears the competency here. What's critical about this competency hearing, Your Honors? There's no trustworthiness. There's no ability to distinguish between truth. Her memory is not good. That's why she was found incompetent. Now, when you move into the CAC coordinator, Ms. Badinsky, who is not a nurse, not a medical practitioner, not a social worker, she never talks to WS about truth. Your Honors, how significant is that? So when we talk about trustworthiness, and now we move into the topic of, well,
excuse me, Counsel, but Bednitsky was the social worker, and as I recall, that interview was not admitted into evidence. Am I correct on that?
The portions of the CAC interview were admitted into evidence, but Ms. Budzinski is not a social worker. She has a bachelor in science, and she works at the CAC Center as, very clearly, Your Honors, a forensic interview. She said that time after time after time. So I'm not going to discuss the protocols, that's all well versed out, but the failures of the trustworthiness and the ability to ascertain the truth. She even said she did not even assess whether WS knows the difference between truth and untruth. And no fault to WS. WS is a little girl, never been to preschool, not this most sophisticated young girl. So then we have this forensic interview, we have the judge interview, and neither one of them, there's no info that was, WS knew the difference between truth and untruth. This is critical. So when this court is sitting here and talking about what's admissible in this confusing world, this confusing state of forensic and medical, which is exactly what this case is about. You have a forensic interview by a self-proclaimed forensic interviewer with a medical person watching outside. Come on. Is that really the protocol? Is that the way to do it?
I'm still having I want to make sure I understand this, because I know the court, it was a bench trial, so the court heard all of this. But my understanding was that the court eventually excluded all of the statements of the child victim and excluded the entire, did not admit the interview either. And, the court's, in a bench trial, the court's presumed to only consider competent, admissible evidence. And if I'm wrong on that, I want to give you the opportunity to clarify that for me.
I'm rebutting that presumption, Your Honor, for one thing, but more importantly, regrettably, I cannot tell you. That's part of the confusion in this record. As far as I know, there was indeed admissions. The medical testimony was admitted. So the nature of the admission is critical there. Oh, forgive me, Your Honor. I did want to reserve 3 minutes for rebuttal here, so I'm running out of time, I think.
Yes, you have just over 4 minutes remaining. So
okay,
if you want to reserve 3, I'll let you know when we get 3.
Thank you. The significant component in all of this is also, by the way, WS, unfortunately, and this is a sad story, but WS said that she has seen pornography where a girl was sucking off a guy. So then we move into the interview. Just in conclusion here, we have the forensic, then we have the medical interviewing mom, then we have her interviewing, then we have her interviewing WS. So the protocol here is inappropriate. The importance of all this for this court, the court erred in admitting the CAC components. The court should have excluded all of that. The testimonial nature was untrustworthy, and the protocol and method of obtaining the medical testimony from afar without even the medical people ascertaining the ability to tell the truth or not tell the truth, all of those things become critical when we take a look at it. In conclusion, when a judge is hearing everything, and Judge Teodosi, I feel you, Your Honor, I really do. But we're humans as lawyers and then judges. The ability and presumption is overclouded. And I'll conclude by saying this. When you look at the record and you look at the confliction and confusion and the great arguments, by the way, of the lawyers and the judge, I mean, this is some real cerebral thinking going on here, not to mention it's almost a law school exam. There was a lot going on in this trial, but there were too many conflictions, and that was why the failure to exclude the CAC was an abuse of discretion. And to have one judge hear everything like this under the circumstances was an abuse of discretion and really ineffective assistance of counsel. And due respect, by the way, to my colleague.
Thank you, counsel. You'll have just over 2 minutes for rebuttal.
Okay, thanks.
Counsel for the state.
Good morning. May it please the court. Counsel Andrea Uller for the state of Ohio. Essentially, Mr. Peck has laid out 4 arguments here the state's position has been none of these arguments have merit. The evidence was sufficient to convict Mr. Peck of rape, sexual battery, and GSI. The verdicts were not against the manifest weight of the evidence. The trial court didn't abuse its discretion in admitting the medical record portion of the CAC interview, which I'll clarify that is the only portion that was admitted over the state's objection at trial as well. And then Peck was not denied effective assistance of counsel. Overall, Mr. Peck would have this court believe that the trial court was at a distinct disadvantage, as he says, in this case, because he waived his right to a jury trial and he requested a bench trial. He, in essence, is arguing that this court's usual presumption that in a bench trial in a criminal case, the court considers only the relevant material and admissible evidence. That's the typical presumption unless it's affirmatively demonstrated to the contrary. He says that's not enough. Yet, as the record in this case demonstrates, the trial court actually excluded that relevant material and competent evidence. Essentially, it appears that the trial court, in an attempt to ensure that it considered only what was relevant material and competent, the trial court excluded statements that were made by the 5-year-old victim in this case for purposes of medical or diagnosis treatment purposes by the victim during the CAC interview. Those statements were admissible, and the trial court in its judgment entries throughout this case clarifying noted that these statements were otherwise admissible, essentially in the portion of the interview where Ms. Budzinski would do the initial interview. The child made statements about who did this, what happened, when it happened. The trial court acknowledged those are all statements that are non-testimonial and that go toward basically the medical diagnosis or treatment. They help that later medical examiner know what to examine, where to start with her interview. And the trial court acknowledged under 8034, yes, those statements are admissible. However, in this case, because the trial court heard that testimony, it did see the entire CAC interview, those portions that the state believed were for medical diagnosis or treatment purposes. It listened to those, reviewed the CAC at trial, and then ultimately, the next day made a ruling explaining that, yes, while admissible under 8034, because we also have that same examiner, the sexual assault nurse examiner who did a follow-up medical examination in this case, that is, definitely admissible under 8034. And so the trial court took the safe route and excluded what otherwise was admissible and only took in that medical report. And so the state's position throughout this has been, well, basically the evidence, the record would support that the trial court considered less than it was permitted to. It certainly can't be said that the trial court considered more. And so there's no merits to Mr. Peck's claims in this case.
Did the court consider any of Budzinski's testimony?
It excluded her entire CAC interview. I believe that since shared testimony was in relation to the clips that were played and it ultimately excluded that, I think it was just limiting its analysis to that medical record, which the medical record portion included statements that were made by WS, save for one statement. I think the statement to the effect of, mom saw dad's wiener out or something, that was excluded as not being for medical diagnosis or treatment purposes, but all of that was considered.
And just quickly at trial, was there any objection to her qualifications?
No, not that I recall. And Ms. Budzinski, they laid at the foundation for both of them. Both had been doing this for numerous years and were qualified as professionals in their field. And that would be my recollection.
All right, thank you.
But overall, just looking at the sufficiency argument to start with Mr. Peck's initial premise, the state reads the arguments that he's made there as really arguments that go to the manifest weight of the evidence, not the sufficiency. When you're looking at sufficiency, the court knows this test, the test is, did the state prove all of the essential elements beyond a reasonable doubt? The answer in this case is yes. The only element that Mr. Peck argued was insufficient to sustain his conviction was the sexual conduct. And because he was actually convicted of 3 counts, and that would be sexual conduct and sexual contact, just to cover all bases, sexual contact is included within the definition of sexual conduct. And so I walked through the analysis in the brief, and it essentially, the state proves sufficient evidence that Mr. Peck engaged in that sexual conduct when he manipulated his 5-year-old stepdaughter into performing fellatio upon him. That establishes the conduct and the contact to meet the elements of that, of all of the offenses. In addition, the SANE, that testimony was considered, it was in her medical report as well, that she observed bilateral redness to the back of the victim's throat within 24 hours of the victim appearing for examination at the CAC. And then the victim had made a statement that her stepdad had shoved his penis so far in her mouth that she almost puked. And they felt that corroborated, on physical examination, that statement. In addition, we also had that GP, the mother in this case, she witnessed the tail end of this. As counsel for Mr. Peck has indicated, she walked in on the tail end of the conduct, saw Mr. Peck with an erection, his penis exposed, and immediately, when GP tried to get her daughter to explain what had happened, she was looking to her stepdad and was very hesitant to talk, but when the mother was able to remove him from the room, her 5-year-old daughter disclosed what had happened and disclosed consistent with what she disclosed at the CAC and consistent with that bilateral redness to her throat. And so, of course, when we're viewing this evidence, in a light most favorable to the state, as this court must on sufficiency, there's no question that the state proved beyond a reasonable doubt all of the elements of the rape, sexual battery, and GSI. And for those similar arguments for the manifest weight, we all know that really goes to the credibility, and credibility lies in the trier of fact. They're the best to determine this. In this case, yes, there was conflicting testimony as to the events that occurred, but it's who was more believable. And I know that counsel has taken the position that we can't believe the statements, even if they came in under 8034 by the child victim in this case, because she was not deemed competent to testify. Well, the Supreme Court on State v. Mutart made it very clear that the credibility, at witness less than 10, those statements come in regardless of whether they've been deemed competent, if the statements are for medical diagnosis and treatment purposes. And that's what we have in this case. And so the testimony, again, going back to, the same, the CAC, even though that was all excluded, if the child court, heard that improperly, they said it's out and they don't consider that, they still have the statements in the report by the SANE that corroborates, what happened in this case. We have, again, that bilateral redness. We have the disclosure to the mom as an excited utterance, throughout the case. And I don't actually recall if that was brought up. It's not in the brief, but, the statements have been admitted. And when it comes down to that, when you're shifting through conflicting evidence, the trier of fact is free to believe any or all, testimony of any witness. And so in this case, I really think that it's a moot point to argue about, what, it doesn't matter, in my opinion, when you look at, what WS, the terminology used, and whether or not that at the CAC, they got into the truth, and having that discussion, and, the difference between, the truth and all of that, because we got into a disclosure, it comes down to that credibility of the witnesses. And even when you touch on, a child statement, and that the witness or the interviewer at a CAC didn't have time to actually go through and follow proper protocol because the child began disclosing, abuse, you can tell still in this case, the state actually had a different witness that came in and said, the protocol looked proper. The child seemed to answer the questions correctly. She seemed to be truthful. They can't actually say if they were truthful or not. And at the end of the day, we have an 8034, statement that's going to come in as medical diagnosis or treatment. And again, that, credibility or trustworthiness, the Supreme Court has said we don't have to get into that. So as a recap on the CAC interview, the state would point that Mr. Peck's main point is that there's a difference. Here he says there were 2 interviews, a forensic portion and a medical portion. The state would argue that, WS simply had an interview at the CAC, as numerous child victims have. That standard protocol. She was interviewed by Ms. Bazinski. The nurse watched from another area. WS was advised, although perhaps a little bit later, that this was for the medical. She would see a medical doctor or a nurse to discuss this. And the state made it clear that those statements were being brought in for the purposes of medical diagnosis or treatment throughout the case. And so in response to Mr. Peck's citation to the direction to NRA-EL in this court, as the state noted in its brief, I would argue that that's wholly distinguishable. We have an actual medical exam that followed up. We have a SANE was actually observing the interview here, and in NRA-EL, it was a interviewer who had relatively little to no experience, and there was never, a nurse or anyone to do a follow-up medical examination or treatment. And so it's wholly distinguishable. It was proper in NRA-EL for this court to say that those statements should have been excluded. That wouldn't be the case here, but ultimately it comes back to the trial court ultimately excluded those statements anyway, except as they came in within that medical report. So I think that it's clear that the statements here were for medical diagnosis or treatment. They're non-testimonial. We don't have confrontation clause issues. We don't get into the credibility, issues or confrontation violation because the child was deemed incompetent because of state v. Mutart. So I just think diving into the record, it's pretty clear what happened. The state briefed, its issues throughout trial as well when it was arguing that, that to the trial court that these statements were properly admissible, and the court, responded throughout trial and put it on the record clearly what was going on and what was being admitted. And so my last point would be to the ineffective assistance of counsel. Everything that Mr. Peck has raised go to trial strategy. We know that the decision, not to request a jury trial is one of strategy. It will not be considered a meritorious reason for reversal as an ineffective assistance of counsel claim. At State v. Tony, 9th District, 2004, Ohio 4877. And he also, Mr. Peck ultimately comes back to this argument, that the trial court was at a distinct disadvantage here because it knew all of the evidence, as this court has properly pointed out. And as the law is clear, there's a presumption that the trial court is only going to consider what is admissible evidence. And the trial court, having determined, that the CAC interview was actual interview portion by Ms. Bazinski, determined that that wasn't admissible, then we presume that the trial court, didn't consider that in convicting Mr. Peck of the 3 out of the 9 counts that he was convicted of. And I think even if we get to that point, as I said, there's no, Mr. Peck wouldn't have an argument that he's been prejudiced in this case because the trial court arguably should have considered that CAC interview as medical diagnosis or treatment purposes. but it didn't. So that evidence would have been properly admissible, and it's, you know, it wouldn't have harmed him either way.
And counsel, I need to let you know that you have utilized your 15 minutes for oral argument
Okay.
this morning.
Thank you
Thank
very
you.
much, Your Honors.
Thank you. Mr. Kudichief, you have 2 minutes and 14 seconds.
Thank you, Your Honor. You know, this is the question being, well, admitted in evidence or heard in evidence. So when we talk about strategy, that's okay, but when do we talk about it's appropriate for a judge to recuse himself after or herself after hearing everything? So the deemed incompetent issue is just a red herring that the government uses here. That's not what it's all about. It's about assessment, protocol, and truth. That was never done. The court was very clear in saying this little girl did not know. There was no clarity of understanding or memory or ability to tell the truth. So you see, and Judge Teodosi, thank you clearly for your questions, because that is demonstrative of the confusion, not even below, but also in this record. So we say, what was excluded, what was included? Well, it's hard to say because everything was heard by everything in multiple discussions, in limine, by contract, by order, by memorandum. So those things are very critical when we talk about problems with strategy or whatnot. And when you go to the manifest weight issues, that's precisely the point. The trier of the fact could not find beyond a reasonable doubt here. The court lost its way, and the court could not find beyond a reasonable doubt because the evidence was insufficient if you take what should have been admitted or not. And that's what the point of this whole appeal about. This court has a unique obligation, ability here to distinguish between this type of information that comes in relative to forensic. The qualifications, Your Honor, were not a topic because it was very clear that her qualifications were clear. She had a Bachelor of Science, but she was not a medical provider. There was no need to object to that. So I'm gonna say this. When the nurse herself names Bryan as the perpetrator, and that's what happened here, then we have to look at, well, what does it take from there? And how does this little girl talk about wiener, flowers? And then finally, the last thing I say, this was not a fair trial. You know, maybe this lets a guilty man go free if this court says the appropriate evidence was not allowed or disclosed or disallowed. The real question is, what if it makes an innocent man go guilty? And that's what I leave this court to scrutinize under this record, under this case, with the nature of the process and procedure. The court erred.
And counsel, I'm letting you wrap up, but please, you're a little bit over time already, so.
Well, thank you, Your Honors. If there's no further questions from the court, then I think, and to my colleague, I think we've made our positions very clear in what I consider a very difficult case with a relatively simple fact pattern.
Thank you, counsel. Thank you both for your presentations this morning. And thank you for agreeing to be present in oral argument via video. Court will take the matter under advisement. We will issue a written decision. It will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.